Good evening, everybody. We're going to go ahead and get started this evening. My name is Nathan Macias, and I'm the president of the Texas Homeschool Coalition and the Family Freedom Project. We'd like to welcome you here this evening as we go through a little bit of some of the details of a recent case that we have been handling in this idea of the title, Inside the Fight to Bring Luca Home. We really want to drive this home to see that what the existential of the family that's being faced by Luca and his parents. But also want to tell you a little bit about what FFP is doing as a whole, and then hopefully wrap up with some questions and answers. Hopefully you have some good questions that you'd like to offer, and we'll be able to go from there. I want to introduce to you tonight the rest of the folks that are here on the screen. We have Jeremy Newman, who's the vice president of the Family Freedom Project. And then Haley Skronich, and she handles all of our policy and marketing for Family Freedom Project. And then we have Larry Walstead, who is our director of our operations and development for the Family Freedom Project. And so hopefully we'll be able to provide insight to anything that you might have later on in the Q&As, but I hope you enjoy the presentation. Here's where we're going this evening. We're going to walk through these 5 items here. First, baby Luca's case in the July 9th hearing, and you'll love the update there. More families we're defending. To expand a little bit, to give you an idea of other families that we are working hard to defend and reunite them as well. Talk a little about who we are and what we do and what we bring to the table for Texas families. And then finally, how you can help. And we'll share a little bit of that, and then we'll follow right into our live Q&A. So with that, I'd like to introduce our vice president and turn it over to our vice president of the Family Freedom Project, Jeremy Newman. Jerry, take it away.
Thanks, everybody. Thanks for coming. We're going to start by just kind of walking through some of the background of Luca's case, which you guys have been following, that we've been talking about for a little while now. And then we'll get into some other cases that we're handling here in a minute. But to start out with, so if you've been following the story, you might know the big picture already, but Luca was born September of 2025. December of 2025, he had this breathing episode that his parents considered to be pretty, concerning, because they called their pediatrician, and the pediatrician's theory was that it was some type of breath holding spell, which is basically where newborns will just, for no apparent reason, hold their breath for an unreasonably long time, and sometimes even pass out from holding their breath for too long. And it's not necessarily indicative of an underlying medical issue. And so the pediatrician said, look, if it happens again, then we'll think it's serious. But as it is, it might just be totally normal. So that was December of 2025, right? So then January rolls around, and he has another episode where he actually goes unconscious. And so the parents are rushing him to the hospital, and they're trying to keep him awake. So Candace's mom is kind of putting cold ice water on his body to try and get him to wake back up while they're taking him to the hospital. And they don't know what's going on. And they get to the hospital, and they get triaged and taken in, and they're doing all of these tests on Luca. And they end up being in the hospital total for a few days. But the events that are most significant are, when you have something maybe neurological going on, what they will often do early is brain scans, right? And there are different types that you can do, but they did an MRI on Luca, and they found that he had bleeding inside the brain and that had leaked up behind his eyes. So those are subdural hematomas, right? When the bleeding leaks in behind the eyes. And it was coming from some type of bleed that he was having deeper within his brain. And there are all sorts of medical explanations that could account for that, right? Just the finding by itself doesn't necessarily tell you what's going on. So the thing that's really significant here is that 7 minutes after that scan completed is when the doctors first noted in the medical records that they believed it was caused by abuse. And so the first question that it kind of prompts in your mind is, how many other medical explanations did you investigate and roll out in that 7-minute window? Right? You can't do anything in that 7-minute window. And so all of the other explanations that could account for that type of thing went uninvestigated by the time the hospital had concluded that it was probably caused by abuse and neglect. And that's significant because you'll hear, Brad Scalise, who's one of the attorneys on this case, you'll hear him say this sometimes, that What it seems like in the hospitals is that the moment somebody uses the term abuse, everyone turns their brain off and they stop investigating other things. And that kind of set the course for Luca and for his family. And the accusation of abuse was made early. And so other possible explanations weren't seriously investigated. Some of them weren't investigated at all. And one example of that is that the medical records were all there for anybody who was looking to realize that since birth, Luca's head had been growing at a dramatically higher rate than the rest of his body. So the rest of his body was somewhere near the 50th or 60th percentile. His head was around like the 95th percentile, right? So dramatic difference between his head and the rest of his body. And come to find out that the reason for that is because he had bleeding going on in his brain. And the fact that his head had been so oversized since birth was an indication that the bleeding may have been going on since birth. And brain bleeds from birth actually aren't that uncommon. It's just that they usually go away, right? Without any type of long-term serious consequences. They usually heal on their own. And you also wouldn't even know that they're there necessarily unless you were scanning the child for some totally other reason. Because we don't just go in and scan every child on the theory that maybe they have a brain bleed, right? So it makes some sense that you wouldn't notice this until you were looking for the problem, right? Until you started having some type of symptoms. What doesn't make sense is that you would accuse the family of abuse before you investigate those types of things, which is what happened to Luca. And so his parents were accused of what's called shaken baby syndrome. And the theory behind shaken baby, as the name implies, is literally that you're holding the child and shaking them back and forth so violently that their brain is rattling around inside their head and getting injured by crashing against the skull. And depending on who you ask and in which branch of medicine, some people will tell you that this is a matter of doctrine, so to speak, that this is a common thing that happens to children, and others will tell you that it's physically impossible for an injury to occur that way. And in order to produce a brain injury like that through violence, you would have to be physically hitting the child on something, right? And of course, if you were, that would produce external injuries on the child, right? So bruising, broken bones, something like that, which is significant because Luca had none of that, right? So no bruising, no broken bones, no external injuries of any kind, which just kind of adds to the mystery of how it is that you get 7 minutes after this brain scan and conclude that abuse must be the thing that happened. So those other things not being investigated, once the hospital concluded that abuse was the likely explanation, they called CPS. And the situation with CPS in medical cases is that by and large, if they get a call from a doctor accusing somebody of abuse, they don't really second guess that. And the reason is because what they'll tell you on the stand, right? The CPS caseworkers usually is, well, I'm not a doctor, right? The doctor said X, Y, Z, and doctors aren't exactly given God status, but it's not far off in court. And it's because they're the only ones in theory who know what the medical explanations are. And so people just defer to them endlessly. And so CPS does that in these investigations. And so you end up in these situations where if the doctor doesn't do a proper investigation the very first time before they refer to CPS, then when CPS does come in, CPS does not do an investigation either because they defer completely to whatever the doctors told them. And since the doctors told them that Luca must have been physically injured by his parents, then CPS didn't do an alternative medical investigation before they removed Luca from his parents. And this, this gets into another point of the case that is unfortunate, surprising, and something that we have on our list to look at for solutions during the next legislative session. But there's a law in Texas that allows people to agree to not litigate the hearing, right? The first hearing you're supposed to have after your child is removed, 14 days after your child is removed, you're entitled to a hearing. And there's a law that allows you to waive that hearing if you sign an agreement with CPS. And so what happens sometimes in these medical cases is that it's very uncommon for you to have an attorney who's handled complex medical cases before. And so they will often, to their credit, what they're trying to do is protect their client most of the time. But if their feeling is there's no way we can beat the hospital in court, right, because they're the one who has all the doctors and all the medical knowledge, then they will sometimes suggest to the family, hey, just don't contest the first hearing, and then do what CPS asks you, and eventually they'll give your child back. And that's what happened here, is that there was another attorney involved in the case who kind of came on early and cold, and I don't think he had necessarily handled these types of medical cases before. So not trying to discredit him so much as say like this isn't an uncommon thing, right, with families in this type of situation, that they agreed to waive that first hearing at the advice of their counsel. And then it was after that point that we were contacted by them. And so when we got into the case, one of the first things we discovered was that this agreement had been signed, which means the first hearing can't be, you can't undo that, right? You can't go back and have the hearing after that. And what they had not been told by CPS when they signed that agreement is that it means nobody will hear the medical testimony in the case until at least 6 months into the case. And the reason for that is that the next scheduled hearing in a CPS case where that type of evidence would normally come up is at the 6-month mark. And so they were not told that by CPS when they agreed to not contest the initial hearing. And what gets even more incredible is that you have that first hearing. Because of that agreement, no medical evidence was put on by anybody, right? CPS didn't offer any medical evidence at all to justify their claim that Luca was in danger. But CPS's next argument that they have made in recurring fashion ever since then is that nobody should be allowed to put medical evidence in at all until we get to final trial. And most people might not realize that final trial in a CPS case doesn't occur until at the earliest 12 months into the case. And so literally their argument is this child was brought into care because of some type of complicated medical situation going on inside his brain. And the first time that this court should ever hear testimony from doctors explaining what happened is after we've had him for a year. And that, in my opinion, this is the cynic coming out of me, that just explodes the possibility that people are acting in good faith here, right? Because otherwise you should want the medical testimony to come out. And so that being the situation, when we got deep into this case, the legal team, we went and helped recruit the legal team with some attorneys that we knew who do these types of cases frequently. So Chris Branson and Brad Scalise were the attorneys that we contacted who took this on. And you guys will see multiple other cases that we've worked on through the years that both of them have been very involved in. And so immediately they started recruiting medical experts and looking through medical records to try and parse out all of the things that had occurred. And then everything was leading up to this hearing that was scheduled to occur on July 9th, right? So this was last week. And that hearing, that is the one I mentioned earlier, the permanency hearing that's supposed to happen around 6 months into a case. And at that hearing, the law states, this is a rule that we changed a few sessions ago. The law states you are required, you must send the child back home to the parents at that hearing unless the state can prove that there is a continuing danger that prevents the child from going home, right? So the purpose of this rule was to create a stopgap in the CPS process because these cases can go on for a year, year and a half, 2 years, and sometimes just get bogged down in bureaucracy and everyone sort of forgets why we came here in the first place. So the purpose of this rule is to level set every 6 months and say, no, you must send the child home. No matter what else is going on in the case, you must send them home unless there's a danger in the home that prevents their return. So it's to keep the entire case focused at least every 6 months on the question of whether there is actually a danger. And so that's what this hearing was on July 9th, the permanency hearing. So the medical team or the legal team traveled to Houston for this hearing that was scheduled and show up in the courtroom, and the judge doesn't appear. The judge who's scheduled in this case, who's been handling this case, doesn't appear. There's not an explanation offered for that. And instead, a brand new judge who has not been involved comes into the courtroom, and she announces that nothing is going to be heard that day at all. And for anyone who's not been inside a courtroom, there's some context here that it is not unheard of at all for multiple judges to be involved in a case. There are usually going to be good reasons for that, right? So on occasion, it's, severe scheduling conflicts that require cases to be moved between judges, or sometimes if there's a conflict that one judge has, they'll move it to the next judge. Sometimes if you appeal it from one judge, it'll go to the next judge. Jurisdiction of the case can be moved if the child and the parents are all living in different places than where they used to. All of those types of things can happen. What's not really normal is to show up in court, schedule to hear from one judge, have that judge not appear, and then have a totally different judge appear and tell you that it's not happening at all. So no explanation was given. And then there was the announcement that was made was that the hearing was being moved to January or July 21st, and a third judge is being placed to hear that case. And they're being allotted 45 minutes to hear it. Now, you'll probably hear in my voice that I'm trying to restrain a little bit my speculation about what some of those things mean, because you're 3 judges in by now, right? You have some experience with the first judge. You don't know the second judge. You don't know the third judge, right? So everyone's a person, right? Judges, attorneys, caseworkers, they're all people. And so we might appear before this third judge and have a great experience. I have no idea. But I can't explain why it would be that you would be shuffled in the space of an hour between 3 judges, and the second 2 having never heard the case at all. And then the most, significant piece of that is they're only allotting 45 minutes for that hearing. And in that 45 minutes, they're supposed to hear all of the evidence that has anything that's accumulated since the last hearing, which has been months now. Plus, they're supposed to handle this question of whether or not there's a danger that prevents the return of the child, which is going to require all of the medical testimony that we've talked about. They cannot possibly do that in 45 minutes. And so we don't know when we show up here for this 45-minute hearing whether anything substantive is going to occur or not. It may end up just being a scheduling hearing, in effect, which, the permanency hearing is supposed to take place every 6 months. And so very quickly, if you're just having these short settings to schedule things, you push past 6 months, which is, a concern about where we might be headed. But CPS is still trying to make this argument that at that permanency hearing, no medical testimony should be allowed. And furthermore, that it shouldn't be allowed by anyone until the trial a year in. And it has now, we're trying to keep this number front and center for people as we progress to keep the context here. We're 180 days into this case now, right? And so what people don't often understand once you get kind of bogged down in these cases is that every extra day that the child is separated from the parents is an added burden and an added source of trauma on the child and on the parents. And you hear this from the families that are in these cases, right? Where they'll show up at the court, sort of prepared to have everything laid out on the table and have issues settled. And instead, the sense that they get is that they are the only ones with any urgency, and that, they'll handle 1 of 5 issues today, and then another couple issues in a week, and then another couple issues in a month. And that's how these cases turn into a year or a year and a half or 2 years. And so the point here is that 180 days is a really long time for children and parents to be separated, especially if the stated goal of the department is to not even hear the evidence regarding why this child was brought into care at all until a year into the case. So we will be keeping you guys updated when we reach the July 21st hearing about the results of that. And, this is, we've had multiple of these cases now with the shaken baby allegation. And they've all gone the same way so far, which is that somebody rushed a diagnosis early on. It resulted in a child's removal, and then everybody felt the need to double down. And then you get months and months and months and months down the road, you discover that, in fact, the child wasn't ever harmed by anybody, and there was a different explanation. The child goes home, and everybody else in the system just kind of walks away and says, oops. Right? It's like that, a mistake was made. If you get lucky, that's the most they'll say, that a mistake was made. And there's this feeling in the system that somehow, even if you're 6 months or a year and a half in before this error is corrected, that it's just that the system was working somehow. And there isn't really this big moment of introspection that you'd expect people to have of how in the world we could get 6 months or a year into a case like this before you hear the evidence that should have been considered by the doctors before a call to CPS was ever made. This next family that you see here on the screen is an example of that. The picture in the bottom left, that's the Canada family. They were accused of shaken baby at Cook Children's Hospital in Fort Worth. We've been helping them. Their case is still ongoing. That was in January that one started. And in the top right there is another medical case. That was not shaken baby. That's baby Rose. You may have heard us talking about that one. We've been talking about that one a lot. And that case is actually going up on appeal. The first brief is being filed this week. And in Rose's case, her parents were accused of not feeding her properly, because when she was 2 months old, she was diagnosed with failure to thrive. And the parents at the time asked the doctors to check for possible genetic causes. The doctors didn't. They instead called CPS. And CPS came in. CPS also didn't check for that. And then they removed Rose from her family. The court ordered them at the first hearing to go get genetic testing done. And then it was a year and a half later before they got the genetic testing done. And then it was another few months after that before they finally informed the court that they had a genetics report in their possession showing that the weight issues were actually genetically caused, not caused by her parents. And then we get all the way to final trial, which was a few months ago. And at that hearing, or at final trial, all of the evidence presented on the failure to thrive issue just definitively proved, even by DFPS's own witnesses, that she had a genetic condition from birth that had caused her to lose weight in the same manner under every caregiver and in every environment for her entire life for 2.5 years. And they still tried to pin this somehow on the parents. And that's this case. The baby Rose case is the one that makes you want to put your conspiracy theory hat on sometimes. The judge in that case, if you don't know how a jury trial works, at the end of a jury trial, the judge is supposed to write an explanation for the jury called the jury charge that tells them what the law is they're supposed to apply. So when the judge did that, he excluded from the jury charge the 3 strongest parental rights laws in Texas. So the jury wasn't instructed on those. And in my personal opinion, the way the issue was presented to the jury was essentially the question of, hey, now that this child has been removed for 2.5 years, do you want to remove the child again from this foster family who has been caring for her during that time and cause her more trauma by removing her a second time? And so the jury voted to terminate their parental rights, and that case is now going up on appeal, even though it's uncontested that her weight issues are coming from a genetically caused condition that no person could have ever produced, and that her weight issues have persisted among every caregiver and through every environment. And the types of cases that come to us are usually the ones where someone in the system did things wrong, CPS or the doctors, and that's the reason they come to us, right? So obviously you don't discount the fact that abuse and neglect does occur, but the problem that we seem to have in our assessment in the system today is that there is nothing in the system at any stage that would incentivize someone to return a child or to not take the child to begin with. What you rely on for those things to occur is the good faith of the people involved, right? You rely on their good judgment to send the child home. But the system does not incentivize it, right? Even the law that we talked about earlier that requires them to send a child home at the 6-month mark, unless there's a continuing danger. Well, you still rely on the judge and the caseworkers and the district attorneys to make that judgment call. And the system doesn't incentivize them to do it. What the system incentivizes is for them to keep the child. And I don't mean this in a malicious way, right? It's not like the system was designed by people hiding in dark alleys trying to snatch children, right? The problem that we have is that the system was designed to make it easy to take children, easy to keep children, because everyone was afraid that if you don't, then some child is going to be left in a home and subject to abuse and neglect. and we should have all done something and didn't. That's the fear. And it's an understandable fear, but the problem is the caseworker who's called, the incentive of that caseworker is to take the child, because if they don't, then the risk is on their head that something might occur and they didn't take the child. But if they do take the child and it turns out they didn't need to, they can just send the child home. That's how they think of it. And same with the judge. When you get before the judge, the incentive is for the judge to allow CPS to keep the child. And you can try and rely on the good judgment of well-intentioned people for the judge to send the child home at that stage. That does happen, but the incentive doesn't promote that result. You rely on the judge to overcome the bad incentive in order to get that result. And it's the same with CPS, that if you want CPS to send the child home, then you rely on their good judgment and their good character to accomplish that result. You don't have anything in the system that incentivizes that result. And so at every stage, every actor in the system is incentivized to take the child and then to keep the child. And you have to have, proper incentives in place to protect children from abuse and neglect. But the problem is, if those are the only incentives you have in the system, then you guarantee that children who shouldn't be removed will get removed because somebody didn't exercise good judgment. They were just following the incentives. The point is, what you incentivize is what you get. And so if we want to incentivize people to send children home, if we want children to be sent home when there's not a danger, or to not be taken when there's not a danger, you have to build a system that incentivizes that. My personal opinion is that financial liability is probably the strongest incentive lever you could build into the system that might produce that result. If you look on the screen here, you'll see some of the sobering statistics of the situation that the system is in now. This is a national number. 1 in 3 children experience a CPS investigation by the age of 18. Some people don't even know that their child was investigated, but 1 in 3 children in the country. And if you're Native American or if you're Black, the number is closer to 1 in every 2 children by the age of 18. 14 months is the average amount of time that a child who is removed stays with DFPS before they get sent home. Only 1 of 3 children who gets removed ever actually ends up going home. And again, we don't discount the reality that abuse and neglect occurs, but the point is, the system is supposed to have the goal of reunifying families. When you take a child, the state's primary goal is supposed to be reunifying that child with the family. We only achieve that 1/3 of the time in Texas. And even more sobering is the fact that Texas is probably the best state in the country on these issues. That last number there, 10,011 children who were removed from their home in 2025 alone, that probably seems like an astronomically high number, but it's half of what it was in 2018 when we started making these legislative reforms, due process focused legislative reforms. So that's a very, very brief point of history on this, is that big legislative reforms didn't really begin until the 2017 legislative session. They've compounded ever since then, getting more and more things passed every legislative session. But since that time, and as a result of those laws being changed, half the number of children get removed. There are half as many children sitting in foster care, half as many children waiting to be adopted, and the number of children who are dying from abuse and neglect has also gone down. And so that last number is kind of the deal killer on the argument people sometimes try and make that, well, if you're not taking as many children, it just means more of them are being left at home and getting abused and neglected. Because if that were true, then more children would be dying from abuse and neglect, but fewer children are dying from abuse and neglect. And so it's a little sobering to realize that in 2018, when we're removing 20,000 children a year, it would seem that at least half of them didn't need to have been removed. And let's see here. I'm not sure.
Jeremy, I'll go ahead and take it from
yeah,
here.
go ahead, Nathan, if you want to take us over from there.
Hey, first of all, thank you, Jeremy. You will hear more from Jeremy and get to the Q&A. Jeremy is definitely, as you can tell, very knowledgeable and wise on how we are approaching what we do. And so before I get into this particular slide, I just wanted to reiterate some of the points Jeremy made. Folks, these are real families that think of the right here, the circles here and pictures here in the top corner of this slide. Think to the mosaic we had on the first slide. These are real families. They're real moms and dads. They're real children. And this is happening to the families. Sure, it's not an idea that every family in Texas, but if you look at the numbers that Jeremy shared on the last slide, it is a significant number of children who are removed, and so often for no good apparent reason. And if they are removed, how quickly do they get returned? As Jeremy noted, there's right now no accountability or no incentive to return children. And that's what we want to be a part of. That's what Family Freedom Project is fighting for, that we want to do this. I've started picking up this term out there that here, especially because another note, most of the families that we are supporting and that you have seen are indigent, in a fancy way of saying they are of low income. They're not very wealthy families. So there's this sense almost that the state will litigate them into obedience, because at some point you can't afford the cost of litigation. And as hard as we work and other organizations to try to help stem the tide, bridge the gap, if you will, often it ends up being where if you just continue the litigation process, at some point these parents lose heart and then they lose their children. So that's where we come in, who we are and what we do. You can read the slides there too. Basically, we stand between families and a system that too often assumes guilt first. Again, we stand in the gap. We're trying to build that bridge that helps these families overcome this existential crisis that they're facing. We bring the experience and the strategy and advocacy and support whenever these families have it in their most dire time and need. We can only imagine. I have 7 children myself, and I can only imagine one of them being removed from our house for no apparent reason. It's very, very disheartening to some of these parents. They don't know where to turn, and we come alongside and guide them through this process. We do the boxes there. We do direct case support. We're in at any given time, we have 4 or 5 cases that we're juggling in different stages of their litigation, that we're trying to help these families reunification and reunite with their children. We always turn litigation as best we can. This is to help improve the system into a legislative policy or action, that middle box there. Because of these things we discover in the courts and in the system and in the culture, we go into the legislature to help fight to get good legislation passed in order to bring about an improvement in culture, an improvement in the system, and therefore an improvement in the families. We want families to flourish, and we believe this tie between litigation and legislation is key. And then finally, in the next box, we bring awareness and tools. That's one of the reasons we do these webinars. Get on our mailing list. You can get updates to these cases, updates to what we're doing. We have legislation that we are trying to get passed, or legislation that we're trying to prevent from being passed. We're able to call, able to notify you to be our first line of defense, to be the ones who are calling on behalf of these families to pass this good legislation, or again, defeat that which is bad. The little bottom line sentence here that I wrap up: Texas families are too often torn apart by invasive CPS investigations. Jeremy gave you the numbers. 1 in 3 of a birth to 18 would likely engage in some sort of investigation with CPS without basic due process. What we've been talking about is due process. So we architect historic legislative reforms, and we win landmark cases. Each one of these cases that we take on will set a new precedence. It takes a lot of work and a lot of effort to do that. Why? Because we want to protect innocent families from unnecessary separation and keep children safe at home with their parents. Folks, this is a high calling, and it's something that we take very seriously here at the Family Freedom Project to bring about. We work hard every day. We're strategizing all the time. We're looking for new tactics to approach the improvement of these cultures and the systems, the judges. I was sitting with a friend at lunch the other day, and he happens to be a child welfare lawyer, and someone at the table asked him, which of these is broken? Is it the judges or is it the system? And he said, yes. Of course, his implication was both. We really have to be concerned about who we elect and who we allow to sit in these judges' seats. And we have to make sure that we have oversight and that we are keeping a hawkish look on the CPS, child welfare system, that we're able to improve and prevent these type of takings. Let's move on to the last slide here, and then we will get to our Q&A. So how can you help? How can you help bring Luca home? And as you saw, directly to bring Luca home, but even indirectly to help the different families that we are helping, bring Rose home, to help the Canada family, and many others that we're helping. We are in dire need right now. We're racing to raise $30,000 to help give Luca and his family every possibility and chance to come home. We truly believe we have the right team. We truly believe we have the right strategy. We have to be able to get in front of the court and be able to make our case. So we'd be grateful if you could help us out. If you could help us out directly, and you can scan the QR code if you'd like to give now, or if you can tell others, share the Family Freedom Project and this information. The recording that we're going to have of this particular webinar, share that with others so that they too can join the team to help bring Luca home. What do we provide? It's right there. Expert witnesses. Folks, these are very seasoned expert medical witnesses who can bring a turn. They can turn an entire jury or a judge if they are allowed to give their testimony. Strategic legal representation. We always want to represent well. Again, I talked about strategy and tactics, and experienced advocacy. We have people who have been involved in child welfare system for a long time that come alongside to help those families make it through the finish line. Because it is, as Jeremy suggested, it's very harrowing on these families. This is hard stuff. And so we have advocacy who can come alongside and help these families. And so in this particular case, they're standing alongside Luca's family to help them get to this end. And so thank you so much again for being on this evening. If you have a heart to give, please take that QR code, give a snapshot of that, and feel free to help us out. Thank you to everybody who have gotten on the webinar this evening. We just want to say we appreciate you. We appreciate your interest. We appreciate your action. And we would encourage you not only to just give, but we'd encourage you also to tell others about the good work at the Family Freedom Project. Our hearts are in this. Our desires to keep Texas families free. Our desires to come alongside, advocate, protect, support these families in their definite need and in their crisis. So thank you again for joining us this evening. We look forward to hopefully having these periodic webinars to keep everybody updated. And we hope you join us again when we do that again in our next webinar. Thank you to everybody. God bless y'all, and good night.